I actually don't know where to start. This is a unique situation. I've never been accused in a public filing of lying. I've never been told that my narrative is sanctionable. So I'm not sure exactly where to start. I will start.
Well, I got some things to say about that, but go ahead. Because and Mr. Doss, I'm just going to tell you, I don't expect attorneys to necessarily like each other. I don't even care whether they like each other. Whether they talk to each other is irrelevant to me unless they cannot communicate in some professional way. But as I've told other attorneys, and particularly, and I'll name him Mr. Bennett, when he came and he accused somebody of some type of misconduct, that when that statement is made, the court has to look at that. And so I made it very clear to him, and I'll make it clear to you. If those are the kinds of things that are going to happen, you better be ready to roll with it, and you better have it. Because if you don't, that's sanction. Ms. Tanner, you may proceed.
Your Honor, as counsel knows, and I think everyone in this room is aware, within this profession, our reputation and our integrity is everything.
Pause right here, because this isn't just emotional, it's strategic. When a prosecutor puts their reputation on the record like this, they're signaling to the court, I don't play games and I don't make reckless accusations. Judges listen closely when an attorney frames the issue as integrity, not ego.
What I've also routinely done in front of Your Honor, as well as other judges, is stand up here and make a point of defending opposing counsels when other people have accused them of anything from lying to misconduct and so on. The reason I make a point of doing that, even though in many situations that has truly not been necessary, is because I want to be very clear how important it is that we don't throw out baseless accusations at people. It's not a new situation to me necessarily to encounter a situation with opposing counsel where we disagree, where we misunderstand each other. I don't take offense. I've gone head to head with some of the best attorneys in this county as well as other counties. And not once have I been accused of what defense counsel is accusing me of. And what bothers me more is I actually started out respecting defense counsel a great deal. As far as I knew, we had a fine working relationship, and I had no reason to believe that anything changed. I think I in this situation, have been more patient, respectful, and understanding of this defense counsel than I would have been with a lot of other counsel for that reason, because we started out respecting each other. Obviously, we've hit a point where that's changed. I'm not sure exactly why, and maybe counsel will enlighten us today, but he seems to have a personal problem. I am perfectly fine arguing law. I'm perfectly fine arguing procedure. I am not fine with personal attacks. Those personal attacks are not just in the written form in these public filings where I'm being accused of all kinds of things. They've also been verbal. They've also been contained in an email communication. I have an email, and quite frankly, Your Honor, I wasn't going to bring this up because I don't take personal offense. This field makes us develop very thick skin, and I don't anticipate in dealing with other people within this field for them to have thinner skin than I do. And perhaps that is my mistake, and I need to be more cautious and aware of people's hurt feelings and how it affects how they conduct themselves. I do want to put this on the record because I think it speaks to why we saw the reply that we saw. This is an email from September.
And now comes the pivot. Watch how this shifts from professional disagreement to documented evidence. Once emails come out in open court, this stops being opinion and starts being record, and that changes everything.
And posture all you want, Marie. Just don't think for a second that I'm not seeing right through you. I don't know what the intent of that email was. What I do know, it's not necessary for what was being discussed. What I know is that it's a personal attack. So I'll just leave it at that. I'll leave it at that. It's not lost on me that unfortunately we live in a society where people who are privileged in certain ways, and specifically being male, think that they can address female attorneys a certain way that differs from how they would address male attorneys. I do this job not expecting to be treated any differently than my male colleagues. I advocate just as strongly as my male colleagues do. Anything less than that would be ineffective. What I don't expect is to get the treatment I'm getting right now from defense counsel based on being female. And that's exactly, I'm just going to call it out, that's exactly what it is. I highly doubt that any of my male colleagues from our office would have been treated the way I've been treated by defense counsel. And even though I probably shouldn't be shocked at this point, having done this job as long as I have, I truly am. Because in working with many different male, female counsels of all backgrounds, this is the first time it's risen to this level. And that's saying something. What's even more concerning to me is that it was done in a public filing.
This is a serious allegation, and not one judges take lightly. Claims of gender-based treatment aren't courtroom theatrics. They go directly to professionalism, ethics, and credibility. At this point, the tension isn't just legal, it's personal, and the court knows it.
But there are times where we have very intense discussions, and that's not out of any kind of intent to offend anyone. I'm quite shocked that defense counsel is as offended as he is by me and the job I've been doing. I was also shocked to read what he wrote. My hope is, because I try to get...
Are you talking about what, and I don't mean to interrupt you, but you're talking about what he wrote in his response?
In the reply. Specifically in paragraph 5. My hope is that counsel's kind of passions and hurt feelings took over, and that logic and common sense just didn't catch up quick enough before he filed that reply. So with the court's permission, I'd like to offer him an opportunity to essentially withdraw paragraph 5 of his reply and ask the court to strike it from the public record. I think that's the appropriate thing to do. I'm not going to sit there and ask for an apology, but at the very least, that is what he could do to remedy the situation. And I do have serious concerns about his ability to efficiently represent his client when he seems to have such hurt feelings and such a personal problem with him. So that might be something he might want to consider. And I'm not going to discuss the case. That's something I appreciate the opportunity to put that on the record. I felt the need to defend myself. Judge Barr was present for a great deal of our conversation, actually all of our conversation in chambers. And I'll kind of leave it at that.
As to that issue, and I have great hesitation in saying this, and certainly Mr. Duss, you can respond if you want to that. When let me just say this before you respond. I've read over the years a number of your pleadings, both from you and both from those in your office. I'm trying to be careful in the way that I put this. What I read when I received that I was surprised. Surprised, and I will say a little bit taken aback. Mainly because, and you know me, I'll just be blunt, I expected better from you. So, and I say that not with any thought as to how I would rule on this issue, because that wasn't really what was playing into my mind. Just expected better. Go ahead, Mr. Doss.
Thank you. This is not personal, Judge. This is professional.
Which part?
What I have put in writing and submitted to the court.
No, Mr. Doss. And I'll let you go on. But no, this was clearly personal. I have been reading briefs and preparing briefs, memorandums for over 30 some odd years. I've been reading them as a judge for over a quarter century.
That line right there, that's judicial disappointment, and it hits harder than anger. When a judge says, "I expected better," it signals a credibility gap forming in real time. From this moment on, defense counsel is climbing uphill.
Or another, you can say whatever you want, but I don't say it unless I mean it.
Understood.
Go ahead.
Well, I'm an honest man. Ms. Tanner is quite skilled at doing one thing and then portraying it as something else. On September 23rd in chambers with Judge Bauer, she brought up a legal issue for which there is no support, no authority. We sought to have a conversation about that, and there was no conversation to be had with Ms. Tanner. And so the exam ended up being adjourned because Judge Bauer at the moment was not in a position to decide any of this. The legal issue before the court is, there's no dispute that preliminary examinations are governed by statutes, court rules, and the Michigan Rules of Evidence. And under those rules, under MRE 4482C, defense counsel at exam at a CSC case may inquire about what is permitted within those rules. The proposition before the court is raised at the last occasion is that for defense counsel to elicit evidence under that rule at exam, there first has to be a motion and offer of proof. For that proposition, there's no authority whatsoever.
Okay, Mr. Doss, can I just stop you since you want to get into the substance of it? Let me just say this. All the years I've been sitting on the bench, the rape shield statute has applied at preliminary examination. Because if it didn't, it frankly makes no sense. To say to someone, we afford you these protections from this intrusion into your life here, but we don't do it here, makes no sense. Because it's one of those things that once the cow has left the barn or the field, it's out. It's just there. And so it doesn't make any sense. Moreover, Mr. Doss, I was a bit surprised by it because your colleague, Mr. Shea, has argued the rape shield at preliminary examination, I believe on 2 occasions, but certainly one before me, and never indicated, never said whatsoever that it does not apply at preliminary examination. Go ahead.
Well, the authority that there is on that issue is to the contrary. I believe it, I put it in writing. I provided the court with the authority. What in fact I did was, I did not submit an advocacy piece. I did not, I'm not asking anything of the court. I'm not trying to convince the court of anything. I advised the court on what the law is. I believe I was well within the rules on going about it in that way. As far as now what Ms. Tanner put on the record earlier, I understood, based on what the law is, that Ms. Tanner on September 23rd was taking an unsupported legal position and was, in a way, misinforming Judge Barr about it and was not having a conversation about it.
What, misinforming Judge Barr that the rape shield applied at preliminary examination?
Yes.
She would be taking a position that has been the long-standing practice in this county. How can you say that she's somehow just come out of with something out of thin air? Show me one case, Mr. Dawson, in this county where rape shield has not been applied and not stood at preliminary examination.
The aspect that doesn't apply is the mechanism of a motion and offer of proof in MCL 750520J2. That aspect is just not applicable at this stage. It comes into play once the case is bound over. And that's the very issue that Ms. Tanner raised. She approached me asking whether I would elicit any testimony.
So, Mr. Das, you paint yourself into a corner. Because if that's the argument, then none of it comes out at prelim. Because the judge at prelim is the gatekeeper of all of that. And so what would actually end up happening is none of it would come in, ever. And then you go ahead and just make your argument in, circuit court.
Well, I understand we disagree on what the applicable law is on the issue. I did put it in writing. It is published.
Oh, but I'm talking about two different things, Mr. Doss. I'm saying if you're indicating that the doctrine of rape shield and the protections that it's afford do not apply at prelim, then the judge, quite frankly, has the option of not hearing that testimony. Plain and simple. And then I just don't let it in. If I'm handling it, I don't let it in. And then you're going to have to deal with it as you want to deal with it in circuit court, which you won't get it in there.
If what the court describes were so, then the court would at that moment disallow the admission of relevant evidence under the court rules.
It's irrelevant. Somebody's past sexual history is irrelevant. I could just say that and I'm done.
Not with the defendant.
Pardon?
That's what the law said. That's what the court rule says, not with the defendant. That is not what the rule is. So, if I can go back once more. The very core item that's at issue is whether defense counsel before exam needs to provide a written motion and offer of proof if defense counsel wishes to inquire into evidence under 404A2C. And the law on that is that no, defense counsel is not required to do that. Defense counsel may inquire under the rule.
Okay. And if the judge says, I need a motion before you do it, what do you then answer?
I would ask the judge, what is the legal basis for making that requirement?
And the judge is going to say, because I said so.
I am hearing that, and yes, I am greatly at odds with it, because there's no legal basis.
Maybe that's the
for that
reason
requirement.
you wear the robe and you don't.
All right. I did submit in writing what I know the law to be, and I stand by that.
Anything additional, Mr.
At this point, Your Honor.
All right, this court is ready to rule so that there's an order that Fashion Judge Barr can deal with. And that is that this court indeed does believe that the rape shield statutes were intended to offer certain protections to potential victims. That evidence, and this specifically needs to be noted, that evidence shall not be elicited at preliminary examination in any greater or lesser fashion, but in the same manner as that evidence would be alluded to at trial. To do otherwise would make the rape shield a nullity in its entirety. And so therefore, that evidence will not be allowed until such time as the court has had an opportunity to see what evidence is proffered at preliminary examination, is going to be proffered at preliminary examination. Tana, you will prepare the order. I will sign off, and that is the ruling of the court. Is there anything additional?
Briefly, Your Honor, regarding the date that this is scheduled for, it's November 10th. I will likely be in retrial unless there are results starting on November 10th. So I was going to see if the court had alternative dates.
Well, the November 10th date is Judge Barr's preliminary exam date, I do believe. Well, what date did it get set for?
November 10th, Your Honor.
Okay, so first of all, there has to be an alternative date. One of the things that occurred, and I don't know if on the scheduling of this, preliminary examinations that week because of Veterans Day, which did not get caught. Normally it would have been Tuesday the 11th. It may have gotten moved to the 10th. However, Judge Barr is not available on the 10th. So the judge that would be available on the 10th is Judge Valvo, but this has been already submitted and he's got some work into it in terms of Judge Barr. There has to be a different date. And
I apologize for interrupting. I was just informed that our witnesses would be available on November 25th, if that's not available.
I'm sorry?
Our witnesses would be available on November 25th, if that's an available date.
That date is not available before Judge Barr. Judge Barr's next date is December 2nd. And just so that I'm clear, he has the 13th, but my understanding is that would not be available that week, so it would be December 2nd. Is there any objection from either side to setting this for December 2nd?
No, Your Honor, that's a good date.
Then preliminary examination of this matter will be adjourned to December 2nd. I will let Judge Barr, my staff will let Judge Barr's staff know that we moved it to that date because he wouldn't have had the 10th in any event. So we'll do it that way. Anything else?
No, Your Honor.
Thank you.
Thank you.
Court stands adjourned.
Recording stopped.